Well, hello there, ladies and gents. It is great to see you again, and welcome back to Closing Arguments. Ryan Ruff here, your moderator. As always, I've got Jack Razumich standing by from the offices of Razumich and Associates, and we're going to be jumping into another criminal law-related discussion, as we always do on the podcast. And if you're a frequent listener to this show, take you back a little bit in time to, I want to say, season one, where Jack and I dove into the concept of the law of self-defense. It can change from state to state, and there's always so many questions surrounding what self-defense truly means within that given state, how it can be demonstrated in a court of law, and we took a dive into that topic. But as many of you know, you joined us as we were covering the Richard Allen case in the greater state of Indiana, which sparked a ton of eyeballs and ears that we are obviously so grateful for here on this podcast. So if you're newer to the show, we thought we would revisit this topic of the law of self-defense. We're going to talk about what that law looks like, the idea of standing your ground, the castle doctrine. These are buzzwords you've probably heard. But also, we're going to then look into where the law of self-defense is popping up into some relevant and timely cases in Indiana. So first and foremost, let's go ahead and bring out the star of our show, if you will, and say hi to the guys. Jack, great to see you today. How you doing?
Hey, Ryan. Great to see you again, as always.
Yeah, good to be back with you. We're talking self-defense. Another, it's really a hot topic these days, especially with some of the cases we'll be jumping into today. But why don't we rewind the tape a little bit, bring our audience back up to speed. Let's talk about the law of self-defense first, then we can get into the court cases. Jack, from a high level, why don't you give me your definition of what the law of self-defense looks like?
Well, it's not going to be my definition. It's going to be the actual definition.
Fair. Let's get the court of law's definition.
My definition of a lot of things is very different from what the actual definition may or may not be. So let's kind of focus on what the law actually is. I think I heard you mention this in the introduction. We did briefly cover this in an earlier episode, but I think at that point in time we did more of an overview of all of the affirmative defenses that are available in Indiana, self-defense being one of them. I did want to come back to this because over the last couple of months, Indiana has once again found itself in the national headlines because of two shooting incidents where people were claiming castle doctrine or stand your ground, which are part of self-defense law, but not the entirety of self-defense law. And it's one of those things that I think people misunderstand, and that's what we're here to address. Mm-hmm. Regarding the law of self-defense, as with all laws, the standard disclaimer that we provide with every episode when we're talking about a legal issue like this, this is the law in Indiana. If you are in Illinois and listening to this or watching this and you had a different outcome or a different situation with self-defense, by all means, please feel free to let us know in the comments. Please don't tell us that we don't know what we're talking about, because the law in Illinois is different from the law in Indiana. We are Indiana lawyers. We have an Indiana perspective on this. So as far as Indiana is concerned, Indiana self-defense law is codified in the Indiana Code. It is an affirmative defense. It says that a person is justified in using reasonable force up to and including deadly force to repel what the person reasonably believes is the imminent use of unlawful force on themselves or a third person. So to kind of unpack that and explain that in terms that people can actually understand, what that means is if you believe that you or a third person is about to be the subject of unlawful force, and an unlawful force has a broad spectrum. For example, if you and I are walking down the street together and someone points at you and says, "Ryan Ruff, your time has come," and I think, holy shit, someone's actually going to attack Ryan. I have the ability if we're in Indiana at least, I have the authority under Indiana law to use a reasonable amount of force to protect you from being attacked.
Well then, Jack, I'd be happy to have you there alongside me.
And the key with that, of course, is again the concept of reasonable.
Sure.
There's the old joke about don't bring a knife to a gunfight. The concept of reasonable is one of those things again. If someone is threatening to punch you in the nose, you probably are going to have an issue if you pull out a gun and shoot them. Now, again, there are obviously degrees on that. If I use Mike Tyson as the example because I'm old and I don't know who current boxers are anymore. But if Mike Tyson in his prime is threatening to punch you in the face, you probably have a little bit more reasonable fear of serious injury, reasonable fear of force that might allow you to shoot Mike Tyson. Conversely, if Jenna Ortega, that's an actress, I know that one because I watch Wednesday on Netflix. Not sponsored, by the way, but it is a good show. But if Jenna Ortega threatened to punch you in the nose, you probably can't shoot Jenna Ortega. You also shouldn't shoot Jenna Ortega anyway. She seems like a lovely person. Also, don't shoot Mike Tyson. He's a really nice guy. I met him once, so
very cool.
But that's the concept of how reasonable is a variation based off of circumstances. You can't. It's not a one-size-fits-all cookie cutter.
Right.
And in fact, when we instruct the jury on issues of self-defense, the jury is specifically instructed that you have to interpret the appearance of danger from the perspective of the defendant when the situation is happening. And that's where stuff starts getting really confusing the way that this is applied in actual court circumstances, because what you're doing is you're asking the jury to objectively determine whether or not the defendant's subjective belief that he or a third party was in danger was reasonable. And that's just complicated. I mean, I know attorneys and judges who have trouble with that, and I never envy jurors who are on self-defense juries because it is one of those things that it is a very complicated thing. What we usually explain to people is, again, the optics are going to really control that. If it's a situation where a normal person would think this is some pretty serious danger, you're going to have a little bit more credence with self-defense. Where it's a situation that you're clearly overreacting, self-defense becomes a little bit more complicated, and that's going to be part of what we talk about with the two case studies we're going to look at a little bit later in this episode. Yeah.
I mean, it's that, and also that gray area in between the two areas. That's what makes this whole conversation so pertinent. Is where does your specific situation fall on what seems to be a spectrum of the law of self-defense? So we mentioned a moment ago there are some of these buzzwords or phrases that exist within the law and the definition. There's the idea of standing your ground. We've heard of castle doctrine. Why don't you walk us through what those two mean and how they apply to this setting?
Those terms drive me nuts, and I think they drive most attorneys nuts because they're not real things.
Okay. Please elaborate.
Part of the problem is we live in an era of bumper sticker politics where if you can't distill it into something that can be a soundbite that's easily consumable or easily sellable, people don't want to listen. And I recognize that's ironic because we will in fact cut this episode up into little smaller sound bites for the purposes of social media. But I at least admit what we do. With regards to castle doctrine and stand your ground, those are potential elements of when you can claim self-defense. They do not modify or otherwise change the basic standards that self-defense has. As we have said many, many times on this show, different states have different laws and different standards for those laws to be applied. One thing that happens with regards to self-defense arguments is whether or not you have what's referred to as a duty to retreat. And the law will impose or require certain thresholds on all sorts of different things. So with regards to the law of self-defense, again, remember one of the things we talked about a moment ago is in Indiana, you are allowed to use a reasonable amount of force. The concept of what reasonable is, that gets decided by the jury. But Indiana does not impose any special duties beyond that. There are states out there that do require, before you can validly claim self-defense as an affirmative defense, that you attempt to escape from the dangerous situation. So, for example, if going back to our example where you and I are walking down the street, I unfortunately can't think of a state specifically off the top of my head that does require a duty to retreat as part of the self-defense statute. But let's say that someone's pointing his finger at you saying, Ryan Ruff, your time has come. If we were in a jurisdiction that imposed a duty to retreat before we could claim self-defense, you or I would have to basically try to remove ourselves from that situation, and we would only be able to claim self-defense if we were actively cornered. Indiana does not do that. Indiana only requires that you that you have a reasonable belief that you are in imminent danger of the use of unlawful force, or a third party is in the imminent danger of the use of unlawful force. That is what politicians had picked up in terms stand your ground. All stand your ground means is that you do not have a duty to retreat. Hence, you are standing your ground. It does not in any way, shape, or form change the dynamic that the use of force that you have has to be reasonable. Standing your ground does not mean that if Jenna Ortega is threatening you, you can shoot her. Mm-hmm. Because that is not a reasonable response.
Right.
That is an over-the-top, excessive amount of force to repel whatever force Jenna Ortega could use against you.
Yes.
So stand your ground does not change self-defense law at all. All stand your ground is that is the political buzzword that discusses the concept of, do you have a duty to retreat before you can claim self-defense?
Got it.
Indiana does not have that. Indiana, as far as certainly during my 20-year legal career at this point in time, Indiana has never imposed a duty to retreat. So from that perspective, you can make an argument that for at least the 20 years that I've been practicing, Indiana has always been a stand your ground state. Stand your ground only became this big political football as a result of Florida changing their self-defense statute not long before the George Zimmerman, Trayvon Floyd situation. And even that, not to get on a side tangent for a Florida case, because we have our own cases to talk about today, but even that was incorrect. That wasn't a stand your ground situation. That was what George Zimmerman's attorneys argued, and argued successfully, was that George Zimmerman had a right of self-defense once the fight broke out. It wasn't a situation. People have been confusing what stand your ground law means for, I don't know, I'm not sure how long ago that case was. Probably about 15, 16 years at this point in time. And it's ridiculous. People think that, oh, I've got stand your ground, I don't have to retreat. It's like, yeah, that's true. You don't have to retreat, but that doesn't mean you can have an unreasonable response.
Right. The response is everything in that matter. But, thank goodness a podcast like this exists, Jack, where we can finally educate those folks and put this argument to bed until we need to do it again next season.
Fingers crossed. So,
right. Jack, now to take it a step further, you gave us the example of you and I walking down the street. Ryan Ruff, your time has come. I don't have to turn and run away. Talk me through the castle doctrine. What does that mean if they come to my home and they tell me, Ryan Ruff, your time has come?
Castle doctrine, again, is a very similar variation on whether or not you have a duty to retreat. Again, these terms do not modify the basic requirements to be able to successfully claim self-defense. They only talk about whether or not you need to retreat. Some jurisdictions, even if they impose a duty to retreat, will not impose that duty if you are in your own home. That would be the castle doctrine concept. It just means that you don't have to retreat from where you are. It does not magically mean that you can do whatever you want and claim, I'm the king of my castle, I can do as I please. The law still doesn't allow that. You're not a micronation that passes its own laws and has its own standards. You still have to adhere to the law as a whole. You're just basically being told, here's where you don't have to retreat from. Here's where the law will allow you to make this claim that you're acting in self-defense. So for a castle doctrine situation, to use your example, again, if someone comes up to your house and is banging on your door and yelling your time has come, it doesn't change the general dynamic of whether or not you believe that you are about to be the subject of the use of unreasonable force, or someone in your house is. It just means that if you believe that you need to use force to repel that, your response has to be proportional.
Right.
So that's what castle doctrine means. Castle doctrine and stand your ground literally just determine whether or not you have a duty under the law to try to remove yourself before you claim self-defense. It does not change whether or not your response is reasonable, because that's what the law requires.
So Jack, as you can tell, there's the where I think a lot of the issues that lie within these self-defense cases, they most likely stem from quote unquote reasonable force, and what that looks like. Is it proportionate to what is being demonstrated upon you, if you will? So really, in summation, it's two variables at play. It's the duty to retreat up against reasonable force. So taking the information that we just covered, let's shift now into the two cases that we wanted to chat about today. The first being the case of the state of Indiana versus Curt Andersen. Set the scene for our audience. It's a popular one in the state of Indiana, but for those that haven't been keeping tabs on it, bring us up to speed and let's get into it.
Sure. So first and foremost, I want to point out that I am not working in either of these cases. These are cases that are of local media interest here in the state of Indiana. They've been picked up outside the state of Indiana, especially Curt Andersen's case. I remember ABC National News had picked that up at one point in time when charges were ultimately filed. But I'm not working on either of these cases. I do not pass any significant judgment on whether they are guilty or not guilty. That is something for their attorneys to decide. I don't have access to anything other than the publicly available filings. And my own opinion based off my own interpretation as a practicing attorney in Indiana with 20 years experience. That said, addressing the case of Curt Andersen first. What the situation with Curt Andersen is a resident of Whitestown, Indiana, which is located in Boone County. It's the county immediately north of us here in Indianapolis. And one morning at approximately 4 a.m., a housekeeper by the name of Maria Florinda Rios Perez de Velasquez, and I apologize because my Spanish is remarkably terrible, so I very well may or may not pronounce that incorrectly. But Maria was working as a housekeeper in Mr. Andersen's neighborhood. And at 4 in the morning, especially after daylight savings time ends, it is extremely dark here in Indiana. Anyone who lives here knows that. We are about as far west as you can be in this state and still be in the Eastern time zone. So we do get the sun a little bit later, but we also get the sun a lot later in the mornings when it's rising. So what happened this morning is Maria went to the wrong house. And I don't have enough information to say whether or not this is the first time she'd been in the neighborhood, if she was looking for a new house that she'd just been hired on, or if she just was having a brain fog, and it happens sometimes. But Maria goes up to Curt Andersen's house and she tries to get in. And it's not like she tries to get in the concept of physically trying to break his door down. She had a key and she put the key in the lock. And if you've ever grabbed the wrong key off of your key ring and put it into a door lock, you know that it doesn't work. Like you can get the key in there, but it's not going to turn any of the tumblers. So Maria is jingling, trying to turn the key, trying to work the lock. It's not working. And then what happens is that Curt Andersen shoots through his door. He shoots through his door, wow, striking Maria, and that ultimately resulted in her death. The evidence, the publicly available evidence as of right now, does indicate that Mr. Andersen tried calling 911. It seems like he was in a significant amount of emotional distress. but he, following that 911 call indicating that he thought people were trying to get into his house, he did shoot through the door, striking Maria and killing her. And that was in early November. It was part of the reason why this got to be such a news story here locally is Mr. Andersen was not arrested immediately, which is not something that you would normally see. Normally with a homicide of any type, unless it is overwhelmingly obvious to the authorities what did or did not happen, anytime there's a shooting, anytime there's something along these lines, usually someone will be taken into custody.
Right, at least taken down to the station for questioning.
He was. I do believe that he was questioned.
Okay.
I do believe that he cooperated with the authorities at his home. I don't think that he was physically taken to the Whitestown police station or the Boone County Sheriff's Office for actual formal interrogation. But I do believe that he did participate and he did cooperate with them and answer their questions. Whether that's good, bad, or indifferent, that's a decision that he and his attorney will have to make later. My general concept is that obviously you have rights for a reason. If you are not exercising your rights, that can come back to bite you. But at the same time, he believed that he had done nothing wrong. And the most dangerous thing you can do, in my opinion, is talk to the police when you think that you haven't done anything wrong. That's why we have attorneys to do the talking for us. But it ended up in the press for a while because, again, we have a Hispanic female who was shot and killed through the door. Obviously, there's an awful lot of, if you're not a white Anglo-Saxon Protestant, backlash right now, to be polite, in the country. And she was killed by a white man in a predominantly white neighborhood. So that got a lot of attention, and that did get the press. Eventually, they did arrest him, and he was eventually charged with manslaughter. But that's kind of the background of the case as it stands.
Okay, so then let's dig into this a little bit here. He talk to me about his claim, at least with what's available on public record, and what do we feel like it's justified? To set the scene again, this is coming off of what we just mentioned a few moments ago with the Castle Doctrine. What say you, Jack?
So he is claiming self-defense.
Okay.
What the press have picked up and what the talking heads on the internet, which, again, hilariously, I recognize that we're currently being a talking head on the internet. But what most of them have seized on is they are arguing that this is an example of Castle Doctrine because he's in his own home. Now, remember what we talked about a few moments ago when we discussed the concept of what Castle Doctrine is. All that does is that literally says that you do not have a duty to retreat from your own home before claiming self-defense. It does not magically make the self-defense claim reasonable.
Right.
And that's going to be where it comes down with this. Now, under the circumstances, I'm not going to say that it is impossible to claim self-defense. What I will say is that, in my professional opinion, it's going to be a difficult defense to maintain. And the reason I say that is when you start firing through a door, the response is going to kind of default be over the top. Remember, the force has to be a reasonable and proportionate response. What we know right now, or at least what we publicly know right now, is that Maria was trying to get into the house. There doesn't seem to be any question about that. But what she was trying to do is she was trying to use a key that didn't work. She was jangling on the door because she thought she could get in, but she wasn't being allowed in. We know that Curt Andersen did call 911. He did call the police. Those recordings do exist. He genuinely does seem to have been in fear for his safety. And that goes back to the concept of what we talked about earlier, which is you have to, if you're on the jury, if you're making the determination on this, you have to determine from the point of view of the person claiming self-defense whether that claim it was reasonable. There have been a number of stories, some from Florida, a number from Texas, I think, that involve the latest so-called TikTok challenge, which proponents of it are referring to as ding dong ditch. People that are actually sensible look at it. It's like, no, these people are going up to these houses in the middle of the night, banging on them and kicking the doors, almost like a precursor to a home invasion, and running off. That's not ding dong ditch. Ding dong ditch is you run up, you ring a doorbell, and you run off. Like,
I think we're not necessarily splitting hairs there on that one. Yeah. that's a very different situation.
You're not doing this at like 3 a.m. to make it seem like a home invasion is happening. So
right.
Depending on the media that Mr. Andersen consumed, because you have to acknowledge that your worldview is sometimes shaped by the reporting that you hear, the news press that you hear. He could have reasonably feared that at 4 a.m, someone trying to get into his home might have been the precursor to an invasion. And that's going to be where that turns on. Because again, like, this isn't a situation where someone is aggressively attacking his house. There doesn't seem to be any evidence about pounding on the door or knocking at the windows or kicking it. There does seem to be indication that someone, again, it's like, it's not contested. Like, she's trying to get into the house. She's not trying to get into the house forcibly, like you would normally think with regards to the concept of, actively preparing to burgle it. But at 4 a.m, if you hear someone jingling on your door or kind of shaking your lock trying to get in, it is one of those things that you can make a reasonable argument that I was in fear of my safety and I took steps to protect myself.
Sure. Jack, I got to ask, is it public information in the case documents that you've been able to see? Were there any words exchanged? Did Andersen try and shout out to anything to
It does not appear to be from the public documents that I was able to review. And that's where the concept of reasonableness is going to become an issue.
Of course. Because I mean, my maybe this is just Ryan's gut instinct would be to, especially if I was armed, and I'm on the other side of the door, I would want to shout out and say, stop what you're doing. If you enter my home, here's what could happen, just to start a dialogue, I guess, in that moment
and that very well may be where it comes down to on this.
Yeah.
Is the action of shooting through the door without making any attempt at notifying the person, what are you doing here? That could turn on it. Mm-hmm. Now, again, the concept of reasonable, like, you are not self-defense. Again, this goes back to the concept of the duties with regards to retreating or not retreating or what have you. Your force response has to be proportional. It has to be a reasonable amount of force to protect yourself from it.
Well, and key word is response.
Response, yeah.
That's the key word.
Yeah, you're not required to do something that might place you in danger if you think that's going to. So one thing that we've seen in other cases, other arguments, people who have been charged with criminal recklessness for firing a handgun, maybe not necessarily in the direction of somebody, but like in the ground or something along those lines. They'll claim, well, I was just firing a warning shot. The law doesn't recognize warning shots, technically. The law recognizes the use of force to repel the imminent use of unlawful force. And if you can successfully argue that by shooting into the ground, while that would have been criminal recklessness under other circumstances, it made them aware I was armed and prepared to protect myself, and that repelled them from attacking me. So, like I said, the concept of what is and isn't reasonable in Curt Andersen's case, it's gonna really heavily turn on how well he and his attorneys can make and maintain a successful argument that his fear of burglary, his fear of home invasion was so reasonable that it was perfectly appropriate for him to shoot through the door. That's going to be, sorry about that. Old chair started slipping on me. So
all good.
We have all the fun bloopers here in the podcast.
Well, Jack, let me ask a question real quick. If he stands to be convicted of the manslaughter charge that he is up against, What does that penalty look like? You know, what's a sentence potentially like? Walk me through the back end of it if convicted.
Sure. He was eventually charged a couple of weeks after the offense with voluntary manslaughter, which is a level 1 felony. Level 1 felonies in the state of Indiana carry potential sentences of anywhere between 20 years as the minimum sentence and 40 years as the maximum sentence. So he's looking at about a 20 to 40 year sentence range on this. His big problem is that someone did die as a result of this. Like there's really only so many things you can do to plead things down when you have, to be blunt, a dead body. Like it's not, you can't argue that you didn't do something when there is a physical body there. So
evidence.
It's like physical evidence. Like there is a dead body that is there as part of this. So he is going to really have to heavily rely on successfully making that self-defense argument, or he's in a lot of trouble. And I'm sure that both he and his attorney are well aware of this. I'm sure that they are reviewing the evidence and determining what the appropriate strategies are for that. And I'm not going to second guess or Monday morning quarterback another one of my colleagues, especially when I don't have that information available to me like they do. But from the outside looking in, if I were consulted on this case and these were the facts that were presented to me, I would have to acknowledge that this is going to be a difficult case simply by merit of the fact that he shot through the door. If he had not shot through the door, it's a little bit stronger of self-defense. Like if she'd actually gotten into the house, you potentially run into a little bit more of a situation. I don't think it's a great situation because, again, you're dealing with a middle-aged housekeeper as opposed to, a hardened gang member or anything along those lines.
Right.
But at the same time, I'm sure that his attorneys will argue that, if he had allowed them to get into the house or engage with them, that could have put him in danger if this really was a dangerous situation.
Right.
That's why everything has to be viewed from the perspective of the person claiming self-defense, and that's why you have the whole reasonable concept on it. But that's
exactly. Yep.
I think it's going to be a difficult defense, but that's an example of, again, someone who is claiming self-defense and the press has picked it up and claimed Castle Doctrine. Castle Doctrine doesn't exist. It just means that he didn't have to retreat from his house. His self-defense claim still needs to be legally reasonable for him to avoid being convicted.
Jack, let's switch gears now. We mentioned another case that we wanted to get into today, State of Indiana versus Maclean Murt. Why don't we talk about this one? We're not dealing with somebody's home. We're dealing with a location that's out in the environment. Give us some background, bring us up to speed on this one, because it very much does differ from the Curt Andersen side of things, but it brings its own unique twist.
Sure. So, State of Indiana versus Maclean Murt. This case is taking place currently right now in Hamilton County, which is another county to the north. Boone County is to the northwest of Marion County, Indianapolis. Hamilton County is kind of to the northeast of Marion County, Indianapolis. This one's from earlier this month. This one involved an individual by the name of Maclean Murt, who was at a bar in Fishers, Indiana, named Britain Tavern. Murt confronted an individual by the name of Justin Burton over allegedly stealing a vape pen that belonged to somebody in Mr. Murt's party. I think it was a brother or cousin. Whomever it was, Mr. Murt confronts Justin Burton over the stolen vape pen. Allegedly, Justin Burton shoves Murt. Now, one thing that is an issue with regards to this is Maclean Murt is in a wheelchair. He is a paraplegic. So supposedly, allegedly, Mr. Burton shoves Mr. Murt when Murt confronts him. Murt takes out a gun and shoots Burton, killing him. So we've got another homicide situation on our hands. And unlike what happened with Curt Andersen, Mr. Murt was very quickly arrested. And also unlike Mr. Andersen, Mr. Murt was ultimately charged with murder. And his case is currently working its way through the Hamilton County court system right now.
Got it. The being in a wheelchair is a unique curveball into what I would imagine is the greater self-defense case that might be made, but let's talk through their claims. Let's talk through, unpack the situation of the defense now for Mert.
So again, much like with Andersen, Murt is making a traditional self-defense claim. Also, much like with Andersen, the press is basically picking this up for the buzzword run about this is supposedly another example of stand your ground, run wild. It's not stand your ground. Stand your ground again, and this will be the big loop that we keep playing over and over on the clips. All that means is that you do not have a duty to retreat. It does not change the reasonableness of your self-defense argument. So once again, the media is getting that wrong. The people who are going on about, this is why we don't have stand your ground, like that is not what's going on right here. His self-defense claim is interesting. And the reason I say his self-defense claim is interesting is because you are correct. The fact that he is in a wheelchair does change the dynamic a little bit with regards to what he reasonably could believe was danger to him. This happened about closing time. Anytime someone tells you that nothing good happens at 3:00 in the morning, this is what they're talking about.
Exactly.
You have a situation where, and again, I don't know. This is speculation. There isn't anything in the publicly available documents that I am aware of that indicates that either Mert or Burton was intoxicated.
Oh, okay.
But if you're at a bar at 3 a.m,
one can believe.
let's just say, for the sake of argument, right now, that both of them had probably imbibed more than a couple of drinks. So you've got potentially the concept of your rational thinking is going to be a little bit out the door. This part,
Right.
Alcohol is a central nervous system depressant. It makes decisions that you would otherwise say no to seem a lot more reasonable.
Right. Jack, this is another one of those, maybe it's not just, questions of mine that maybe it's not displayed in public record, but on Justin Burton, the individual who had shoved Mert being in the wheelchair here, was there any report of maybe Burton having any sort of weapon on him, a knife, a concealed carry, anything like that?
I don't know. There's nothing that's been reported in the documents that I was able to access and the documents I was able to review for this episode.
Because just at face value here, this is feeling like an uphill battle on a self-defense claim.
It becomes a little bit more complicated, and the wheelchair does make a little bit of a wrinkle on this.
It does. It does.
Because again, let's go back. Let's go back to the Jack and Ryan walking down the street example. If you're in a wheelchair and someone is screaming at you and yelling at you, your options for defending yourself against a fully able-bodied person
are
a lot more limited.
Yeah, absolutely.
So that's where it gets back again to the concept of the reasonableness of what Mert's actions represent. Because to successfully maintain a self-defense argument, again, you have to be able to show that your fear, that not only was your fear reasonable, but that your response was proportional. Without more information, it is difficult for me to say how easy or how difficult it will or will not be for Mr. Mert to maintain his self-defense argument in this case. The wheelchair aspect of it does change things from the concept of what his initial belief or his initial concern would likely be.
Mm-hmm. And what feels reasonable to respond.
Correct.
Based on his environment.
Correct. And I want to be very clear. Burton pushing Mert, that is a crime itself. That is not the fear of imminent use of unlawful force. That is legitimately unlawful force. And that goes back to one of the things I think we talked about at the top of the episode is force is force. Shoving you is force. Threatening you is force. Actually hitting you is definitely force. being shoved if you're in a wheelchair, again, like your options for defending yourself are probably a little bit more limited. What I don't know right now is I don't know if it's one shove. I don't know if it was multiple shoves. I don't know what conversation was going. Certainly, and again, like we're using a little bit of common sense here. 3 a.m. at a bar. Mm-hmm. Probably nobody is in their best mindset. I don't know what Murt may or may not have said to Burton with regards to the concept of, hey, you stole my buddy's vape pen. But certainly Burton very well may have been overreacting with regards to his response too, on the concept of shoving a guy in a wheelchair. But does that mean that Murt's response of shooting him is automatically reasonable? I think that there is certainly the concept that Murt has the ability to claim self-defense. I certainly think that a reasonable person would look at that and determine, okay, where now the concept of self-defense is appropriate. Mm-hmm. The issue with him is going to turn on whether or not his response is proportionately reasonable, because that's going to be the issue on that. Right. And you're correct. Issues like, was Burton armed? Was there anything that visibly looked like Burton was armed? What was Burton saying prior to being shot? Those are all things that are going to factor into the self-defense argument a little bit more effectively, because that will help to, again, really establish what Murt's mindset is with it. Mm-hmm. Honestly, of the two cases, I think that Murt probably has the stronger one with regards to making the self-defense argument. And that's, again, just based off of the concept that you have an able-bodied person shoving a disabled person. And the disabled person's options for defending themselves are going to be more limited. And because they are more limited, his ability to claim I was afraid and I needed to use force to defend myself, that's going to be more reasonable up front. Whether or not his response of shooting him is proportionately accurate, that's going to rely on information that I simply don't have access to. But I do think that of the two cases, Mr. Murt does have the more valid self-defense claim, in my opinion. Mm-hmm. Although you are correct, it is difficult. It's one of the things. Proportion is key on this. That's the reasonable aspect of it.
Sure, Jack. In both of these situations, you've got a small amount of time to make a big decision in your life. For Curt Andersen, he felt fearful for his safety and decided to pop some shots through the front door. In Murt's situation, he felt threatened and needed to respond in a very heavy way. But those massive decisions were made in such a small amount of time. And then you find yourselves with, manslaughter charges, court documents piling up, and an argument that ultimately has to be won. So this very well goes back to a conversation that you and I have had many times on this show, and that's about making sure you got the right team in your corner to help navigate what happens after those key moments. So, Jack, as we wrap up today's discussion, and we can sit here and we can say, well, you got to evaluate, your duty to retreat, and then you need to evaluate what reasonable force looks like. Well, in a lot of instances, folks don't have time, or they don't think they have time in the moment. They just react, and it might cause them to be in a situation where they need legal representation to fight and help argue their thoughts, their feelings out in court. Jack, for anybody out there that could use a team like yours, should they find themselves in a situation like that, what would be the best way somebody can reach out to you and your team to have that conversation and to start navigating these, what would be uncharted waters for them?
Sure. And you're correct. These decisions are made in a split second, and then we spend a lot of time arguing them afterwards. In my career, we have defended a number of different self-defense claims over the years. Every single one of them is different. They all do go back to the concept of being able to work with your attorney to factor in some of the stuff that we talked about very specifically with regards to Mr. Murt's case. What was being said What did you see? When did you see it? Who else may be able to back this up? Speed is of the essence on this. You were making, you made these decisions about what force, whether you needed to use force and how much force to use. You made those decisions in a split second. You really should make sure that the next fastest decision you make is having an attorney to defend you on this. Our office telephone number here is area code 317-983-5333. If you call that number, we will set you up for a free case evaluation to discuss what your options are, what works, what doesn't work, not just with self-defense cases, but with any type of legal representation matter that you might need help with in the state of Indiana. That telephone number is answered 24 hours a day, 7 days a week. Case evaluations are always free, always will be. It does not cost you anything to pick up the phone. All that you are investing is a little bit of time to have your questions answered and to determine what your rights actually are and how to go about protecting them appropriately. So we do encourage you to call, not just with self-defense cases, but with everything else that you might have that needs an attorney. We are happy to help you on that.
It quite literally and figuratively pays to have somebody in your corner. So, Jack, appreciate your time today, diving back into the law of self-defense, of course, chatting up the two cases. I know we're going to keep our eyes on these cases as time moves on. And when a verdict does come down, we'll be sure to update you guys, our listeners here on the show, and then bring up any additional notes or conversational points that seem to be derived from those verdicts coming out. But Jack, appreciate you and your time, and I know you got clients to serve, so let you get back to doing that. But thanks so much.
Absolutely. Don't forget to like, share, and subscribe. Every like and share helps me buy a new chair that's not going to just sink out of the picture on this one. That was a bit of a surprise today, so definitely like and share, subscribe, share, all the fun YouTube stuff like that. But beyond that, pleasure as always, and we'll see everybody hopefully next month.
Well, folks, there you have it. As Jack just mentioned, make sure to hit that like button, that subscribe button, that share button on whichever platform that you checked us out on today so that you don't miss out on any future conversations where Jack and I sit down and we bring unique case studies to you. We dive into different criminal law related discussions. We've got a lot of content coming down the pipeline for you guys, and we're excited to be sharing that with you soon. So make sure to subscribe so you don't miss out. But look, for Jack, I'm Ryan. We're going to go ahead and say so long now, but we appreciate each and every one of you stopping by and being with us today on Closing Arguments.